Did you hear we had an election? Yes, we did. You know what the big news is? Marijuana is legalized. Yay. No, just kidding. You know what this means, of course? Clients are going to come to you and say, can you find me a house that's good for growing marijuana?
Already has the lights.
This is going to happen. You know, this is going to happen. Which leads to an interesting question, though, but in all seriousness now. The previous administration was, as a deliberate policy, was not basically saying to states where you have some type of legalized medical marijuana or recreational marijuana, we're not really going to enforce, you know, federal law if against people that are complying with California law, or Colorado or Washington or Oregon or whatever it is. The new administration hasn't made that call yet, right? Which we don't even have a new administration yet. So before you start showing people all these marijuana houses, maybe you should wait to see how aggressive the federal government's going to be on enforcement in the new administration. And another question that comes up all the time, can a landlord, even today in California, can a landlord say to a tenant, I don't care about your medical marijuana prescription, you cannot have marijuana in my rental property? Or do they have to reasonably accommodate the tenant's disability? And the answer is you don't have to allow it, period. Because it still violates federal law. And that's not going to change regardless of the sort of the policy of the new administration. So if any of you guys are landlords and you don't want smoking of anything on the property, that's perfectly legitimate. You can continue to do that. I'll get off this marijuana thing in a second, but the other thing that comes up a lot is people in certain parts of this state, a lot. Guess what I'm talking about? What parts of this state am I talking about? I go to some parts of this state where I'd say every single house is growing marijuana in the backyard. Guess where I'm talking about? Humboldt County, you're right. But it's not just Humboldt County. Anyway, do you have to disclose to the buyer that the seller was growing marijuana? We say yes, because it probably has some actual effect on the property itself. I mean, most residential properties aren't built and designed for agriculture, so they can have an actual environmental impact on the property, so we always say disclose that one. Those are the issues that come up a lot for us. But anyway, let's talk about what you really want to talk about. I want to talk about all the new laws. I want to talk about all the new forms that are coming out next month. And I want to talk about a couple of interesting lawsuits that sort of illustrate things that realtors shouldn't do. That's probably good to know, right? Did you hear about this case where the realtor, this is true, showing a buyer a house, it's along the coast. And as they're walking through the house, the buyer says to the realtor, what's that funny smell? It's kind of a musky smell. And the realtor says, don't worry, that's just sea air. Buyer says, okay, good, it's just sea air, I'm not worried about that. Buyer moves into the house. The smell is getting worse, it's bad. The buyer says, I better check this out now that they bought it. And they do some investigating. Guess what's causing the smell? It's not sea air, it's not mold either. It's an underground ruptured septic tank. And an underground oil tank that's leaking. Imagine the combination of those two smells.
That's unique.
It was horrible. The buyer had to literally abandon the property. But of course sued the realtor, saying, you know, if you had not told me it was sea air, I would have probably investigated further while I was in escrow and maybe not even bought this house. But once you told me it was sea air, I didn't worry about it and I just bought the house. So they sued and they won. And the realtor paid a judgment of $275,000. Now, all the realtor would have had to say was, I don't know exactly. That's the answer that too often a realtor doesn't want to give. Attorneys are the same way. You know, any attorney, I don't care what their field of expertise is, you ask them a question, they're going to come up with an answer, right? Because attorneys always want to, we know the answer. Well, realtors, you know, you're the same way. You want to appear that you know everything, and you do know a lot. But when you venture into things you really don't know, that's when lawsuits happen. I mean, the classic, we always tell realtors, your job when it comes to disclosure is to identify red flags. Your job is not to diagnose the cause. The classic example we always give is, you're walking through the house and you notice a stain on the ceiling. So you say to the buyer, look, stain on ceiling. You don't say, look, evidence of roof leak, because you don't know. Might be, logically, but that's not your job. But your job is to point out the stain on the ceiling. So you may say, well, can't the buyer notice that themselves? Of course they could, but they don't. You're trained to look at a house. And you're trained to look at a house and see what doesn't look right. Because you know what the difference between you and just the random buyer? Do you have better eyesight than the buyer? No. You've probably looked at a lot of houses closely, and you know what houses are supposed to look like and not supposed to look like. I mean, a lot of you realtors here I've known for 30 years. I bet you've been in every single house in Bakersfield. Because if you work long enough in a community, you will be in every single house. So you know from experience, I've seen a lot of houses and that just doesn't really look normal. So you point that out. And then they take it from there, hire an expert to determine the problem. You know what I mean? I mean, that's sort of the key thing we always say. And on your Avid, we always say, write down in detail, on the northwest corner of the ceiling of the family room, there is a stain, a blue-gray stain, 7 inches by 6 inches by 3 inches. Seriously, the more specific, because if it'll come up in a lawsuit and you identified that particular, they'll say, well, the realtor didn't tell me about the stain. Which stain didn't they tell you about? And then they look at the Avid and case dismissed. So anyway, that's a good tip of a lawsuit that illustrates a good point. All right, let's talk about the new laws. How many laws do you think the governor just signed? Too many is the answer you're saying. 800 or so. 800. How many of those affect real estate in any way? 750. No, about 50. If you want to see all 50, you go to our website. There's a handout, 2017 New Laws Affecting Realtors. Let me give you like the top 10, okay? And you can remember these. You don't have to write it down. I'll give you the top 10 easy to remember new laws that you really need to know about. Speaking of Governor Brown, every year it happens. I was waiting for it to happen. It didn't happen until about a month ago. But at least once in my entire 30-year career at CAR, at least one realtor has come up to me and said, what was it like being the governor of California? You all know that's my name, right? It's not... But I come across new realtors, and they are convinced I was the governor of California. So, anyway, let me give you the top 10 new laws you need to know about. Number 1, most important by far, probably, is the fact that 2 months from now, January 1st, 2017, all single-family homes in California have to have low-flow plumbing fixtures. Toilets, shower heads, and indoor faucets. Okay? January 1st, 2017. Now, if your home is newer than 1994, it was built that way. So you're good. How many of you, like me, own a home that's older than 94? All right, put your hand down. How many of you, like me, have not yet retrofitted your plumbing appliances? All right. What if we don't do it by January 1st? What's going to happen? The toilet police are coming for you, so... This is a point of sale. This is not a point of sale retrofit. We're supposed to do it whether we are selling or not. This is the exact opposite of smoke alarms. Smoke alarms, we can sit in our house, and if the smoke alarm isn't working in one of the rooms, we say, the heck with it, I'll fix it eventually, but we're not violating any laws. When we sell, though, we have to fix them and certify that we've done it. It's the exact opposite with the plumbing fixtures. While we're sitting in our house, if we don't do it, we are violating the law. But once we sell, we don't have to fix them. We can say to the buyer, you know what, I was supposed to do it. The toilet police never got me. It's now your problem. In other words, there's no requirement that you do it at a point of sale, but there is a requirement you have to disclose it. So first of all, as homeowners, just talking to all of us, we all should do it by January 1st. Now let's talk about how does this law affect realtors. Because this law says not only must everyone do it, but when you sell your house starting January 1st, you must disclose to the buyer whether or not you've done it. So yes, there's going to be a new question on the seller property questionnaire, as well as a new question on the exempt seller disclosure, whichever one you're using. And it's not okay for the seller to say as an answer to this question, I don't know. You sort of have to know. So what's going to happen is, I predict, you tell me if you agree, sellers are you're going to take a listing in January, the seller's filling out this form, and they get to this question, and they read it says, are you in compliance with this law? And they're going to say to themselves, I don't know. Then they're going to look at you, the listing agent, and say, do you think I'm in compliance? What is your correct answer? I don't know. Very good. You're paying attention. Thank you. You're not a plumber. But that's not going to be a good enough answer, is it? They're going to say, well, help me figure it out. I think you're all going to have to get to know a plumber. And I think every plumber in California is going to have a new service. If they're not already offering it, they're going to A, certify, or B, upgrade your plumbing for a fee. Because it's got to be done. You're not plumbers. The average client's not a plumber. But it's got to be done, and it's got to be disclosed. The other issue is, our home inspector is going to call this out. I think so. Are lenders going to require it? We don't know yet. I've asked 3 different lenders. They all gave me the same answer. We haven't decided yet. But you know what's, so in other words, even if the seller doesn't know, buyers are probably going to demand some assurance that it's been done. Lenders might demand some assurance that it's been done. So we all have to just sort of get ready for this. None of this is really the realtor's responsibility. I'm just saying you're going to get dragged into it, I'm sure, by your clients, by the buyers, by the lenders. In other words, I'm predicting it's probably going to turn into a point of sale requirement, because people aren't going to necessarily do it on January 1st. A lot of people just don't even know about this law. You're in real estate, you know about this law because you're in real estate, but the average homeowner, do they even know they have to do this? They're probably not going to find out till they sell. And then they're going to find out. If any of you guys are landlords, you better do it, because your tenants will figure this out, you know that. And they'll use it against you. So if you're landlords, you should do it. If you're dealing with commercial and multi-unit residential, you have 2019. You got 2 more years. But 2017 is the deadline. So there's going to be a new question on the SBQ, a new question on the exempt seller disclosure, and the other change is, you know, we got a form called the carbon monoxide detector notice. It is now going to be the water conserving plumbing fixture and carbon monoxide detector notice. So in other words, it's the same, you're already using this form, you're already giving this form to your buyers, so you don't have to think of a new form, but I'm just telling you, you'll see by December 12th that this form that used to just talk about carbon monoxide detector talks about something else. So that's easy, you don't have to remember that, it's just the same form. And the new question on the SBQ and the ESD, and you're good. You're good to go. Any questions on just this?
Why is it on the SBQ and on the TDS?
Very good question. His question is, why is it on the SBQ rather than the TDS? You always got to remember that TDS is a government form. And this happens all the time. The government passes a new disclosure law, but they don't go to the trouble of amending the TDS law. We can't just change the TDS. It's a government form. It's not our form. We print it for you, but we can't just change it. Which is why we have an SPQ. Did you know the first 10 questions on the SPQ, which are also the same 10 questions on the exempt seller disclosure, those 10 questions are 10 laws that the state has passed since the TDS that they have not incorporated into the TDS. Now we have 11 laws that the government has added since the TDS law without amending the TDS. So it's just as mandatory as the TDS. It's just the government didn't put it on the government form for you. But we still got to disclose it. It's required. So, you know, that's the answer to that. Another question? Yeah.
If we have a listing that we take now or December,
right,
the habits are old.
Right.
They're not. You said that one part is going to be changed.
Yeah, good question. What if you take a listing now? Well, obviously, the seller at this point doesn't have to make this disclosure. But what if you take a listing now and it hasn't sold by January 1st? Very good question. Historically, usually they don't enforce things if you've already entered into escrow before January 1st. But if you haven't even entered escrow, I'm thinking in the back of my mind, I'm probably going to give them a new SBQ on January 1st just to answer that one new question. That's a very good question. I can't guarantee that you have to do that, but the safe thing to do is that. If you get into escrow before January 1st, I would say you don't have to worry about it. Well, okay, here's another interesting question. What if you take a listing today, or you took a listing last month, and it's going to sell, it's going to close before the end of the year. And then on January 1st, the buyer who just bought this house realizes somehow, hey, I got to upgrade my plumbing. Then they come back to you, the realtor who sold them the house in November, and say, why didn't you tell me when you sold me that house in November that I was going to have to upgrade my plumbing? Well, you did. It's already on the TDS. So in the very fine print that nobody can read on the TDS, it already says on January 1st, 2017, you've got to upgrade your plumbing. So you've already taken care of that. It's already on the TDS. And by the way, another thing is, you know what's already on the TDS on the first page? The bottom right corner of the first page, there's a checkbox that says water conserving plumbing fixtures. It's been there for like a year. I've been telling people right now, if you're a seller selling your house, you come to that point you don't know, just don't check the box. You're not required to do it, and you're not even required to know whether you've done it. So the safe thing on that is just don't check the box. My point is, as of January 1st, you can't just plead ignorance and say, I just don't know. You have to sort of know. Okay? One more thing. The house you're selling is newer than 94. So you figure, hey, it's good. Can you guarantee that that house is in compliance? No, because people mess with their plumbing once they buy it. Especially since they didn't have enough power because it was low flow.
Yeah.
So they've upgraded it into high flow. Well, on January 1st, they're supposed to change it back to the way it was when they bought it, if it was a newer than 94 home. And you're not going to police that. It's not your job to police that. So I'm just saying, when you're listing a 1998 house and the seller gets to that question, you can't tell the seller, oh, for sure you're okay. Because how do you know the previous seller, unless you're a plumber and you know what you're talking about, you don't know if a previous owner messed with it. You know what I mean? So you're not the expert. That's what I keep trying to tell you, but just be aware of the stuff that's going to happen. All right? All right, we've taken care of law number 1. Law number 2, very important laws. There are only 2 really important laws. This is the second and last one, okay? And you've got a year for this one. You have a year. Effective January 1st, 2018, realtors, and not just realtors, all real estate licensees, you have to have your BRE number on everything. For sale signs, open house signs, flyers, social media, internet, magazine, newspaper, classified ads in the newspaper for rental vacancies. If your name is there, your BRE number's got to be there. Not just first contact, not just business cards. Like today, it's just business cards and maybe advertising material about you that you give to a stranger. It's well beyond that. It's going to be pretty much everything. Okay, so you have a whole year to do this, but your BRE number's got to be everywhere. Not only that, your name has to be everywhere. You can't even do blind ads and say, call me. And I don't think any of you want it. You want your name out there. But theoretically today you could say, call blah, 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 call Jim Broker. Of course, that would violate the Code of Ethics, because the Code of Ethics requires you to put your broker's name on everything that you were doing. But you wouldn't be violating any law. Starting next year, not only do you have to have a BRE number on everything, but you have to have your name on everything, and you have to have your broker's identity. Your broker's identity is currently already required by the Code of Ethics. And most of you want your name out there because you want your name out there. So you're not really going to change those 2 things because you've already been doing those 2 things. But I do know some licensees who put out their, rental property available, called Jim Broker. And that non-realtor wouldn't be violating the law today. A year from now, that non-realtor would be required to put his or her broker's name and his name, not just call me, I'm a broker. Okay? So that's good news. Non-realtors are going to have to comply with that. You're going to have your name on everything and your BRE number. The only exception is signs that don't have your name. For example, this way to the open house. So in other words, but even that under the Code of Ethics, I don't know if you knew this, even that under the Code of Ethics is supposed to have the broker's identity. I don't know if you guys collectively crack down on that. In other words, it'd be perfectly okay to say this way to the Coldwell Banker open house, this way to the RE/MAX open house. I suspect a lot of you just say this way to the open house. To me, that's a technical violation of the Code of Ethics, but I don't think anybody really cares. And that's not going to change. In other words, you still don't have to have your name on an open house sign or a directional sign. But if you do choose to put your name there, you're going to have to put your BRE number. Does it have to be a particular font size? No. You better be readable. But anyway, you know what? There's a good thing about this. Have you ever seen realtors who market and they just use their first name, like they're Madonna or something? Call Judy at RE/MAX. Who are you, Judy? What's your last name? That violates the law. You're supposed to put your last name. You can't just market with your first name. Or there's some realtors out there who market with a nickname. Call Skip at Coldwell Banker. That's a violation too. What if you say call Skip Johnson, the real name? Is it okay to use a nickname first name if you use the real last name? If you have your BRE number. But all this is going to be solved next year, because you're all going to have your BRE number on everything, and then they're not going to care if you call yourself Madonna or Cher or something. They're not going to care if you have a nickname. They're not even going to care if you don't have your last name, because you're identified. They know who you are because you're going to have your individual BRE number there. And there's only one of those per person, so everyone's going to know who you are. All right? Y'all ready for that? Yeah.
If you are doing a rental property,
right,
and it's your own personal rental property,
right,
you still have to have your BRE?
No. It's your own property, unless you're sort of doing it as a realtor. You're sort of offering it, you're offering commission, all that stuff. If it's just your personal property, the fact that you have a license doesn't mean you have to do any of this. Right. Okay.
On Facebook, do you need your BRE number per post or just on the page?
Very good question. And the answer, every time I say something like very good question, means I don't know the answer. Obviously, right now, you wouldn't have to put it on either place. But they say social media. We have to interpret, we're hoping, here's what we're hoping, that between now and January 1st, 2018, the BRE comes out with a regulation clarifying any uncertainty, like the exact question he raised, because this law does raise some uncertainty like that. So we're working with the BRE. Hopefully they'll come out with a reg, because they're the ones who are going to be enforcing this. So they sponsored this law, the BRE did, and CAR supported it. But basically, there are still unanswered questions like he just raised, so we'll hopefully get an answer to that and other questions by January 1st, 2018. Okay? Now, related issue. Some realtors market as a team. There's a whole separate set of rules for teams that are in effect right now. For example, let's say I'm a realtor, Gov Hutchinson, and I live in Culver City, California. Let's say I work for Culver City Realty. I take a listing listed by Gov Hutchinson at Culver City Realty. Is my BRE number required? No, not till a year from now. Can my name be bigger than my company's name? Yeah, if my broker doesn't care. My broker can care, but the BRE doesn't care. Now let's say instead of listed by Gov Hutchinson, I want to say listed by the Hutchinson team at Culver City Realty. Today, I have to put my real name under the team name, and I have to put my BRE license number, and my team name can be no bigger than the company name. So that's a rule today. That's not January 1st, 2018. So right now, if you market as a team, you have to follow different rules. What if I market as a team, but I put each member of the team on the, well, then you're not marketing as a team because you're naming every member. And you have to worry about these rules. What about next year? Same thing. I mean, if you put every members of the team's name on the advertiser, you have to put every BRE number too, but you don't have to worry about this relative size of the name thing. But if you just use a team name, you got to worry about the size. You know what else? If you want to call yourself a team, you only have 3 choices now. Team, group, or associates. What if I want to call my team the Hutchinson Gang? Doesn't that sound cooler? I can't do it. I absolutely cannot do it. Unless I'm a broker associate. Because I'm a broker associate, I can get a DBA. And I can go directly to the BRE and say, would you give me a DBA Hutchinson gang? I don't know what they'll say, but let's say they say, yes, you've got it. Can I now use it? Unless my broker has a problem. Because when you're a broker associate, by definition, you're working under another broker's license. And that broker could say, good for you, you got this nice DBA. You want to work for me, you can't use it here. You see what I'm saying? So everything is complicated by the fact of what the BRE says you have to do or can't do. But regardless of what the BRE says, your broker can say, this is my company, these are my rules. Here's my rule. On all marketing, my name has to be 5 times bigger than your name. Don't like it, don't work for me. You know what I mean? So brokers can have their own rules, but everything I just told you is what the BRE is saying. Regardless of what your broker cares about, this is what we care about. Okay?
So if you're getting signs made for your team now,
Right.
you have to you can't do that law for 18 in advance. You gotta.
You could. So your question is, I'm getting signs for my team today. Assuming your broker's okay with what you're doing, the minimum is that these signs would have to have at least the name of one of the members of the team and that member's BRE number, and you have to worry about the size of the letters. So that's right now. Nothing's going to change. The only thing that would change a year from now would be is if you had other names on there, you'd have to put their BRE numbers too. But otherwise, your team rules aren't going to change a year from now. Okay? By the way, how many of you are finally used to saying BRE rather than DRE? Be honest with me, how many of you are still saying DRE? I hate to tell you this, it's about 50-50, it's going back to DRE. So don't order these new signs yet. We will probably know within a couple months. So, but by the way, let's say they go back, and let's say at some point you're saying BRE and it should be DRE, or you're saying DRE and it should be BRE. You're not going to get in trouble if you say BRE or DRE. Of course, you want to look cutting edge, top of the line, absolutely right, but you're not going to get sanctioned for that. Or you can just put license number. You don't have to put anything. Right now, technically, you're supposed to put Cal BRE. I know plenty of people who just put BRE. And I still know people who still put DRE. No one's getting in trouble for this. What you're getting in trouble for is you don't have a number at all next year. That's when you get in trouble. All right?
What about if you put name riders?
Riders are okay. It doesn't have to be on the body of the sign.
But do you have to put your BRE number on the...
A year from now. A year from now on riders, you know what, you're going to comply with the law by means of riders. Not today, you wouldn't have to. All right? A couple more laws. A couple more laws affecting realtors, right? So we got the big 2 out of the way, and actually the team name was just, the team name law was just modified slightly. Did any of you remember that the team name rule, for a while they're required that if you market it as a team, you had to put your broker's BRE number there too? That they took away. So you don't need your broker's BRE number on anything, and you won't need it next year either. So in no circumstance is the broker's BRE number required on anything. Okay? All right. Next law affecting realtors. Remember I mentioned broker associates a little while ago? Do I have any broker associates in the room? Here, I'm talking to you, the rest of you, zone out for a second. Okay. Right now, on the BRE website, there's 2 categories of licensees: brokers, salespersons. Broker associates are listed under brokers. Next, a year from now, another 2018, the BRE website's going to have 2 different categories. Instead of brokers, salespersons, it's going to be brokers and associate licensees. Broker associates are going to be listed under associate licensees, not under brokers. Unless you also have your own business in addition, in which case you'll be in both places. No big deal. One more law affecting realtors. I know this is not relevant to anyone in this room, but have you ever heard of a realtor who actually messes up? and gets in trouble with the BRE, and they get disciplined. They get their license revoked, suspended, restricted, they get fined, they get a letter of reprimand. Do you know currently that discipline remains on your public record for your entire life? Whether you like this or not, there's a new law that says starting next year that if you've had discipline on your license for over 10 years, you can petition to get it removed. And it's going to be a case-by-case thing. But maybe you had something 20 years ago, you violated the advertising rules accidentally, inadvertently, and you're tired of having that on your, anytime someone looks you up on the internet, they find out that you've been disciplined by the BRE. There'll be a process now to go to the commissioner and say, hey, I've been good for 20 years, I didn't kill anybody, you know, can you remove it? And they might get it removed. I mean, some violations, you know, are never going to get removed. You killed your client. You know, that's going to, that'll remain probably for the rest of your life. You know, that's always going to be it. All right. Those are all the laws. That's about 5 laws. I'm only going to talk about 10 laws. That's the 5 laws that affect realtors directly. So we got those are the important ones. Are there any other laws you should know about other than, I mean, you know, if you want to hear all of them, you can get this handout. But are there any other laws realtors should really probably know about? Well, I know a lot of realtors do property management, and a lot of realtors have rental properties. And maybe a lot of you are thinking about getting rental properties. So let's tell you, I should tell you the new laws about rentals, right? Those of you who don't have anything to do with rental properties, once again, zone out for a second. But you might be interested anyway. Are any of these laws going to be good news for you? No, of course not. Every new law you're going to hear about is going to be anti-landlord. So I'm probably going to convince you not to be a rental property owner in California. But you got to know the new laws anyway. Are you ready? First one, there's going to be a new form next year you're going to give to your tenants. What's this form, Gov? It's the bed bug form.
Oh, of course, yeah.
Yes, July 1st next year for new tenants, January 1st, 2018 for existing tenants, you're going to give your tenant the bed bug form. So yes, CAR is going to come out with a bed bug form by next July. What is this form going to say? It's going to say, hey tenant, have you ever heard of bed bugs? This is what they look like. It's going to picture of bed bugs. Say this is what they do, this is their life cycle, and if you have bed bugs, you should tell your landlord. Do you think you need to give a form to a tenant to tell them to tell you? They're probably going to tell you anyway if they have bed bugs. But there's a new form you got to comply with. By the way, what if the tenant tells you, you know, I've got bed bugs, get rid of them? Do you have to? Yes. But what if it's their fault, as it probably is, that there are bed bugs? Because as a smart landlord, when they moved in, you had them certify that this house is not infested with anything. So it's obviously their fault that they're bed bugs. Does that mean you still got to get rid of them, but you can charge the tenant the cost? Of course, they're going to say, no way, it was me, but you'll probably win that argument. Anyway, so that's okay. But the second part of this law is interesting. The second part of this law says, if you're a landlord, you're a property owner, and for some reason or other you hire a pest control guy or gal to come out to inspect the property for termites, bed bugs, rodents, whatever. If you hire a licensed pest control person out to the property, the new law says you must tell the buyer that you did it and what they found out. Today you don't have to do that. Today, as a property owner, you can call out the pest control person, not even tell the tenant they were there. Next year, that's part 2 of the bed bug law. You have to do this when you hire pest control people, okay? And guess what? I love this part. It says if it's a inspector for bed bugs and he finds bed bugs in the common area, you have to tell all the tenants. How are there going to be bed bugs in the common area? I'm trying to figure that out.
Everybody sleeps outside the courtyard, maybe?
Maybe, I don't know, but that's what the law says. So if you have bed bugs, what if you find termites in the common area? You don't have to tell the tenants. You only have to tell the tenants if you find termites in their portion of the property. But if you find bed bugs anywhere, or I should say in the common area, not in a different unit, what if you find bed bugs in Unit A? Do you have to tell Unit B? No. But if you find bed bugs in the common area between Unit A and Unit B, again, you got to tell A and B. But not if you just find termites, only bed bugs. I don't make this stuff up, I'm just telling you the law, okay? So,
I guess because termites don't bite you, they only eat that.
I guess so, you know, I guess so. I guess bed bugs are becoming a big problem, yeah.
What about eviction?
What about eviction?
Well, I mean, in case they created the problem.
Good question. So they created the problem, can you evict them for that? Probably not. You can bill them for the cost of eradicating the problem. If they don't pay you, you can evict them. But just in and of itself, unless of course it's a month-to-month tenant, in which case you don't need a reason. So that's a perfectly good reason, because you don't need a reason. It's not discrimination to evict them for that. Speaking of rental properties, does the landlord have an obligation to do a periodic inspection of your property? No, you don't. You have an obligation to do a periodic inspection to make sure the smoke alarms are working. But you don't have the obligation to look at anything else. How often are you required to check out the property to see if the smoke alarms are working? How often? Yearly. She said yearly with a question in her voice. She's right to have a question in her voice because there is no rule. The law just says periodically. So what do most people do? Yearly. So it's probably the standard of care now, yearly. What if you want to do it every 6 months? That's probably okay. What if you don't trust the tenant, so you want to do it every 2 weeks? They could probably say that's unreasonable. By the way, that's your way to find out about other things about the property, right? On my way to the smoke alarm, I'm going to walk through the rest of the house. I'm going to take the slow way. Which leads me to another question. I just said you don't have an obligation to do a periodic inspection of your rental property. Do you have the right to do a periodic inspection of your rental property? No, you don't unless you put it in the lease. The tenant can say, no, you can't come in. Well, I'm checking the smoke alarm. So you were just here a week ago for that's too soon. So a smart landlord puts it in the rental agreement. We do not have it in our standard rental agreement, but you can add it very easily. That tenant agrees the landlord will do an inspection of the property every 6 months or whatever. Put that in your lease if you want the right to do that. Okay? Are there any other laws affecting rentals that you need to know about? Getting back to smoke alarms, do you know you have to have a smoke alarm in every single bedroom on a rental property now? Some of you are thinking, I thought that was true before. No. Before, if you have an older house that's never been renovated, you only have to have one smoke alarm in the entire house. Unless the city where the property is requires more. Does Bakersfield, as a city ordinance, require one in every bedroom? It does? If that's true, then forget what I just said, do what Bakersfield said. For example, LA, where I'm from, the city requires one, so the fact that the state law changed doesn't matter. It was already required. But if the city or wherever you are doesn't require one in every bedroom, you didn't have to before, but now you do, so who cares? Just remember, no matter where you are, if you got a rental property, put a smoke alarm in every bedroom and the hallway outside the bedroom. So you got 2-story house, 2 bedrooms on each floor, you need 6 smoke alarms. Bedroom, bedroom, hallway, bedroom, bedroom, hallway. Okay? Anything else with rentals you need to know? You know the environmental hazards booklet you give to buyers? Now you're going to give it to tenants, but only on leases of more than a year. Most of your leases are a year or less, right? So you're not going to still do it. But if any of you do more than 1 year leases on residential property, or any type of property, give the environmental hazards booklet. I forgot to say one thing on the water conserving plumbing fixtures. Remember I said 2017 for did I already say this? Commercial and multi-unit 2019, right? So we all got to do it by 2019. All right, good, I did say that. Anything else with rentals you need to know? Does anyone do commercial leasing? Talking just a couple of you, make it quick. There's a new mandatory commercial lease addendum you must give to all your new commercial tenants. And this is going to be incorporated into the commercial lease form next time that's revised, which won't be until next year. But this is an interesting thing for all of you to know. This new commercial lease addendum basically tells you must tell the commercial tenant if your property has ever been inspected by a certified access specialist to see if it's in compliance with the Americans with Disabilities Act. You notice I didn't say you have to inspect your property, you have to call out a certified access specialist, but you have to tell the tenant whether you have. And if you have, what did this person find out? Why is this relevant to you? I bet every single one of you works for a brick and mortar real estate company, don't you? Let me ask you something. Are members of the public invited to come into your office at any time? Yes. Could a disabled person enter your office if they had to? You have to ask yourself this question. Which leads to an interesting question. What if you have a real estate company on the second floor of a mini mall, right? That's where your office is. And there's no elevator on this property. Are you automatically in violation of the law? No. It's a case-by-case analysis. And chances are you're not in violation. That's why you see a million two-story mini malls in California without elevators with stores on the second floor. Are they all in violation of the law? No, they're not. Because the analysis is always, well, how much would it cost to retrofit this property to provide access compared to what's the revenue of this company? And generally the analysis is, if you compare how much revenue this company makes out of that office compared to how much it would cost to put in an elevator, it's not fair to require you to put in an elevator. Sometimes it is, though. Or some businesses you have to put in a ramp, some you don't. How would you know whether your particular business is okay or not? Well, you could wait till you get sued, then you'll find out, you know. But the way to find out before that is to hire a certified access specialist to come out to your property, and they will give you an opinion you can rely on that says you're okay or you're not. So that's just a good tip for you to know as business owners. As realtors who represent commercial landlords, this is a new form that you must immediately give any new commercial tenant. So that form already came out as an emergency form from CAR, a new commercial lease addendum that you must give any new commercial tenants. Okay? Any other new laws? Well, yes, there's two types of people you can't discriminate against anymore. Who am I already not supposed to discriminate on? Race, religion, color of skin, country of birth, age, gender, disability, marital status, family status, meaning whether you have children, sexual orientation, or source of income. This means you have to rent to lawyers. You know, you can't say, I'm a lawyer, I don't rent to you. No, it's source of income, right? All right. Does anyone know the two new categories you can't discriminate against? I heard someone say criminals, and that is correct. But don't get too upset. Here's what HUD said. HUD says, some landlords are saying, I do not rent to anyone with a criminal record. HUD says that's too broad. In other words, you could say, I don't rent to someone who's got a violent crime, drug crime, sexual crime, fraud crime, felony. But let's say their only crime is 30 years ago he got drunk in college and got cited for disorderly conduct. HUD says that's not a legit reason to not rent to someone 30 years later. Because if you have that as a policy, you're going to exclude a lot of people that you shouldn't be excluding. Maybe even people in this room. I don't know. Or maybe a misdemeanor, you know, DUI or something like that. So in other words, don't be complete. You can be you don't have to rent to criminals, definitely, but not all criminals. Okay. All right. Yes.
Do we have to have some kind of guideline of what we accept and what we don't accept?
You don't, but just see. Here's the problem. That's a very good question. When you don't rent to someone, do you have to tell them why you didn't rent to them? No. But just if they sue you, have a reason. And if they sue you, don't have the reason being you had a misdemeanor disorderly conduct 25 years ago. You know what I'm saying? So no, you don't have to advertise your rules, and you don't have to tell the individual tenant you rejected why you rejected them. But to avoid lawsuits, it's always safe if they do come back at you in a threatening way with their lawyer, that you have any reason. Like, I had another tenant who had a better credit score than you. That's why I didn't rent to you. I had another tenant whose income was more than you. That's why I didn't rent to you. So you can always have objective criteria. Yeah.
How about child molesters?
Yes. Don't rent to them. Yes. Don't rent to them. Yes, you don't have to rent to them. Okay, so that's interesting. By the way, you want me to tell you some more bad news?
Why not?
Why not, right? It's my job. Do you know in California, you're going to hate this. Why do I tell you this? Just to make you mad. Whatever, I don't care. You rent a house, right? You're a landlord, you own a house. Not a condo, a house. And you rent this house, and you make it very clear on the lease, as our lease does, you can't do a business out of this house without my permission. This is for you to live in. Okay. A month later, your tenant announces, we've just opened a daycare center. You say, you're in violation of lease, you can't do that. Oh, yes, they can. In the states of California and New York, you're not surprised, those are the only two states, daycare centers are protected. They're not considered businesses like any other businesses. If they have a license to put in a daycare center, and they have fewer than six or fewer kids they're taking care of, you can't stop them. Isn't that amazing?
What about insurance?
What about insurance? Can you require them to pay extra insurance? Is that what you're saying?
Yes.
Yes. Liability insurance. Not damage to the property insurance, but liability for the kid getting hurt insurance. You can require them to get that, and you can require them to have you to be part of that insurance. But you literally cannot prohibit them from doing it. I didn't know that myself until this year. When someone was in that situation, they said, I was told I can't evict them. And I said, of course you can evict them. And then I said, maybe I should check that out. Sure enough, California and New York.
If the property required retrofits or some kind of accommodations by getting a license, they modify the property.
And they're willing to pay, the tenant's willing to pay for that modification and retrofit it back when they move, you can't stop them. Yeah.
I walked into one of my rentals in the backyard and I just freezed because I saw a trampoline.
Okay, you're not liable if someone gets hurt on that trampoline. As a landlord, you're not liable. Yeah. You don't like it, but it's not your problem.
Just call it.
Yeah. So, one more time, sorry?
It's against the CCNRs or the HOA rule.
Very good question. So in other words, it's not that the landlord has a problem, it's that the HOA has a problem. You're in California, and they still can do it in California. Now you could have, HOAs have a little more leeway. HOAs can at least regulate this with reasonable regulations. I mean, you know, obviously we're talking about single-family homes, not condos. You could say condo's not appropriate for a daycare center, you know, because that's unreasonable. But, you know, I just brought this up to get you mad. This isn't even a new law. This is a law I wasn't aware of. I just had to share it with you, you know? I'm just like, just to give you more reasons not to be a landlord. But did you remember I told you there's another category you can't discriminate against anymore? I didn't mean daycare centers. You can't refuse to rent to someone because the tenant doesn't speak good English. Now you already know you can't discriminate based on national origin, so that's probably related, right? But some landlords have been sort of getting around that by saying, I'm not renting to you. It's not because where you're from. It's nothing to do with where you're from. I don't care where you're from. It just happens to be you don't speak English, and I don't feel comfortable renting to someone who I can't communicate with in English, which is the only language I speak. HUD has this came out about a month ago. HUD says no. In other words, if they're willing, you can obviously have another reason not to rent to them, but if that's your only reason to choose between two tenants, don't let that be the reason. Because HUD says, hey, they can always get a translator. What if their translator isn't good? Too bad for them. They shouldn't have signed it without being sure what they were signing. In other words, they can never come back and say, I didn't know what I was signing. Too bad, you should have got a translator. I did get a translator. You didn't translate very well. Too bad, you should have got a better translator. You know what I'm saying?
Oh, okay.
But you can't, as a landlord, say, that's the reason I picked this tenant over this tenant. Because this one speaks English and this one doesn't. First, you first, Joe.
You answered it in part, but so are they responsible for acquiring a translator?
Yeah, if they want one. Or they can just sign it blind and hope for the best.
So you have no obligation.
Not only do you have no obligation to give him a translator, I don't recommend doing it even if you want to, because then you're going to be accused of providing a bad translator. What if you yourself are bilingual?
Don't do it.
Don't do it. They're still going to say, you misled me, you didn't translate right. Plus, if you are the translator, that means the lease was negotiated in that language, which means you have to provide them a written copy of the lease in Spanish. Whereas if they have a translator and you speak to the translator in English, you didn't negotiate the lease in Spanish. You negotiated it in English. You do not have to provide a Spanish language version of anything. All right? Okay. Enough bad news for landlords. And that's, yes, I'm sorry.
Can a property manager require a valid California driver's license and a key card?
Good question. I think you're entitled to some form of ID. But what about a passport? You know, this has never been ultimately decided. One of you can be the test case on that one if you want. You know, that's a good question that when I say good question, what do I mean? Don't know answer. Yes.
I heard a rumor at CAR that Section 8 might be coming up.
I didn't want to upset people even more, but the rumor is correct. But we're fighting it. You guys are collectively, here's what he's talking about. Right now, you don't have to be a Section 8 landlord. A tenant can show up and say, well, I can't afford your rent, but I qualify for Section 8. And you can say, I'm so sorry, I'm not a Section 8 landlord. Well, I want you to be a Section 8 landlord. Currently, you have the right to say, I don't want to be a Section 8 landlord. There's a proposed bill that would require you to be a Section 8 landlord. Yes, we are opposing this. I'm pretty confident we're going to win this one.
Well, that gives you no choice as a property owner.
Yeah, right. I'm giving you more and more reasons not to be a landlord. By the way, the city of, I think it's Santa Monica, or is it San Francisco? One of those already requires you to take Section 8 tenants. They already require you to be a Section 8 landlord. I really am not thinking that. The reason I didn't bring that up is I really don't think that's going to happen. But you are right on the rumor you heard. It was not a rumor. That you are correct. Okay? All right, none of you want to be landlords anymore. I got that. Okay. I'll just a couple more new laws, and then we'll talk about the forms. Okay? And then we'll be done. It's not going to take a whole 2 hours, in case you're wondering. Okay. So those are all the laws affecting realtors. And those are all the laws affecting property owners, per se. Are there any other laws of these top 800 laws that I think you should know about? Well, there's one disclosure law. It's just a clarification. It is affecting you, but I think it's not a big change. Let me ask you a question. Do you have to disclose, you're listing a property, you know someone died in the house 4 years ago. Do you have to tell the buyer?
Depends on how they die.
I heard several answers. One said no. One said depends on if they ask, and one said depends on how they died, and the third one said depends on if they ask. I'm glad you all asked the right questions. It was a little bit unclear. There was an argument that depending on how they died, maybe you did have to. In other words, if it was a murder or something, you did have to. So there's a new law that clarifies once and for all that you do not have to disclose a death that occurred more than 3 years ago, no matter how it was caused. So black and white, period. Yes, you do not have to disclose a death on the property you're selling if it occurred more than 3 years ago, no matter what the cause was. Now, the other comment I got was, what if they ask you? And you're right. This law does not authorize you to lie. So if someone says point blank to you, I heard someone got shot on this property 5 years ago. Is that true? Don't say I don't know, because that's lying. You're allowed to say, I'm not going to answer that question. Which will, of course, will answer the question. Because if the answer were no, you would have said no. By saying I'm not going to answer, you're in effect saying yes, because otherwise I would answer. So technically, you know what I'm saying? You can't lie. You can't say I don't know if you do know, and you can't say no if the answer is yes. You technically don't have to answer the question, but it's going to be kind of hard to not answer the question without answering the question.
going over the disclosures with the buyer, and
Yeah.
the question that asks if there's been a death
Right.
on the property, and the buyer looks at you and they say, well, what if there was a death more than 3 years ago?
Right. And you're going to say the seller didn't have to check that box. The seller could have not checked that box.
My standard answer, if I genuinely don't know, is I don't know.
Right.
So then, at that point, should you go further and?
No, you're done.
If they want to know at that point, you write it, put it in writing and have the.
I mean, I guess they could, in other words, the seller fills out the SBQ, they answer that question, and the seller says, are you aware a death occurred in less, and they say no. And your buyer says to you, does that mean that there might have been a death more than 3 years ago? Yes, as far as I know, maybe no. The seller didn't have to tell you though, and I don't know. And you can leave it at that. If they want to go further, I don't know how they'd go further, check the police records, I don't know. They could go further if they wanted to, but they don't have to. You don't have to. Yeah.
The neighbors are probably going to tell you.
Yeah, I mean, it's always the neighbors. It's always the neighbors. But I'm saying you don't have to go ask the neighbors. Which leads to an interesting question. I think what you're saying is when you put up the sign, the neighbor comes over and says, don't forget to tell the buyer about the death of 4 years ago. Still, you don't have to disclose it. But you know what I would do in that case? I'd go to the seller and say, this will probably come up when your neighbors will probably tell them when they move in. You want to tell them anyway? But you still don't have to. You don't. The law now is clear. You 100% do not have to. You're right. It wasn't clear before. It is now 100% clear. Yeah.
So if they ask you that question and you say, I don't know.
Right.
They say, okay, you giggle it off, whatever. They close escrow. The neighbor then says,
Right.
oh, by the way, yeah, they died 4 years ago
Right.
in the property.
Right.
Do they then have recourse?
No. Unless they can prove that you knew when you said, I don't know. So don't say, I don't know if you really don't, unless you really don't know. Yes. Quit making faces. You know, this is, I don't write this stuff.
I experienced one just recently where the seller's mom got murdered in the house, but it was.
How long ago? How long ago? More than 4, more than 3, in other
It
words.
was more than 4.
More than 4, yeah.
And then, well, and it was all over the news.
Yeah. See, that's I mean, of course, the law is never black and white. Let's say you were listing the Charles Manson house. Now, that house, by the way, has been torn down. As usually these notorious houses are, because no one wants to buy them. But you're right. It's a material fact that it was the Charles Manson house. So even though it was, so in other words, if that house was still around and you were listing it today, you wouldn't have to disclose that there was a death on that property. You're disclosing that it's a notorious house that everyone knows about. So maybe in your case, that house is notorious enough. You know, I mean, maybe it is. It's a notorious enough house that everyone in Bakersfield knows about it. So a stranger from outside Bakersfield is entitled to know that, not because it was a death on the property, but because it's a notorious, famous place. So you're right. It gets a little more complicated.
What if your buyer requests that you ask the seller if there were deaths past 3 years? The seller doesn't have to answer, but with their
Right.
So you can say, well, we can ask.
We can ask them, but they don't have to answer.
They don't have to
Yeah.
Really?
Yeah. Interesting. This is an important issue. It comes up. It really does.
This might be kind of a dumb question, but what if the person didn't die in the house, but like on the front yard?
Very good. That's a good question. The question is, what if they didn't die in the house, but they died in the front yard? They're still on the property. So if someone starts dying on your property, get them out in the street or something. Get them you know, if you shoot the burglar, carry him out to the street first while he's still breathing, okay? You know. We gotta make a light of some of these things here. Yes. Enough on death, okay? All right. Any other new laws? Does Bakersfield have the PACE or HERO program? Yes. Oh, I heard some bad feelings in those voices. Anyway, there's a new law that now requires the PACE provider to disclose to the homeowner what the negative aspects of a PACE lien are, in that it has super priority. So in other words, if you, the homeowner, decide to put on your solar panels or whatever, you finance this improvement through a PACE lien, that PACE lien, to a PACE financing, that financing now becomes a lien that's superior to a mortgage lien, which means if you try to sell your house in the future, it's going to be harder to sell it because buyers can't get loans to buy your house because the lender doesn't want a lien that's going to be junior to another lien. So you either have to pay it off or find a cash buyer. So the good news is, at least now that these PACE providers must provide a disclosure form to the homeowner, basically explaining what I just said. It says, these are the risks of doing this. And you have a 3-day right of rescission once I tell you this, even after you've signed the contract. And they can no longer make representations like, well, this improvement's going to increase the value of your property by $30,000. That would have to be certified. That would have to be supported by a certified appraisal or a broker price opinion. More work for you. Okay, so that's a new thing to know about. Maybe one more new law that you need to know about, and that is, you know what a granny flat is, or a second unit? Does Bakersfield have a second unit ordinance? Someone said yes, some said no. Okay, all right.
So that there can't be a stove in there because Lennar is actively building next generation homes. That building code requires they can have a kitchen, they can have a sink, kitchenette, hot plate, microwave.
Well, the point is,
I think if it's attached to the house.
The point is, the reason I raise that is because some cities don't have second unit ordinances, which means in those cities you can't build a second unit. Communities that do have a second unit ordinance, you can build them as long as you comply with the city's second unit ordinance. Well, the state of California is basically making a decision that we have a shortage of housing, so we need more second units. Therefore, any community in California now that doesn't have a second unit ordinance, you can build second units. And communities that have second unit ordinances are now have to compare their ordinance with the new state ordinance to make sure it's not too strict. So someone in Bakersfield will actually have to take a look at that and see if Bakersfield's ordinance is not too strict and makes it too difficult to build second units in Bakersfield. Because there's now a state regulation sort of promoting second units. Okay? Yeah.
Where would we find that stipulation?
Oh. You want me to give you a citation? Is that what you're saying? It's on this nice little handout I just told you about. Maybe as I'm talking to you, I'll try to find it. But it's definitely right there. Yeah, go to our website, because that's one of the top 50 laws that we have here. So, and I'll give it to you before I leave today. All right, enough new laws. That's enough. That's like the top 10. That's all you need to know. And only like the top 2 are the ones you really need to know about: the water conserving plumbing fixtures and your BRE number on everything. As long as you do those 2, you're pretty good. Oh, by the way, on PACE, have you heard the good news? FHA says in most circumstances now they will finance loans on properties with a PACE lien. The other good news from FHA is they're going to make the requirements to make condo complexes FHA compliant. They're reducing the owner occupancy requirement from 50% to 35%. So that's good. All right. Got some good news for once. Yeah, that's good. Another thing I forgot I should mention, if any of you guys are employers, you have people working for you who are not independent contractors, you are aware that minimum wage is going up. Now, if you have fewer than 25 employees, it doesn't go up till January 1st, 2018. If you have 25 or more employees, it goes up January 1st, 2017, but then it's going to go up $1 a year every year until it hits $15. Yes, that's only in California.
What's it going up to January 1st?
1050. And that's only if you have more than 25 employees.
When does that condo rule go into effect?
I believe it's December 1st. The condo rule, he said, when does that go into effect? One other thing, I don't know if any of you care about this, but if maybe you have children who have jobs, employee jobs, or maybe you have another job, or somebody knows another job, but this is big news. Have you ever heard the distinction between exempt employees and non-exempt employees? An exempt employee is someone with salary. I'm an exempt employee. Who's my boss? You guys are my boss. Thank you for being a good boss. That's why I've worked for you 31 years. You're a great boss. But I'm an exempt employee. What am I exempt from?
Hours.
Overtime. In other words, you work me hard. And even though I work more than 40 hours a week most weeks, if not every week, I don't get anything extra. Believe me, I'm very well paid. I appreciate very much the way you guys take care of me. But the point is, I'm exempt from overtime if I work extra. A non-exempt employee is an hourly person who, not only do you pay them by the hour, but once they hit a certain level, you pay them time and a half. Some employers, though, they try to get around this by they have low-paid employees, but they characterize them as exempt. They say, you're salaried. You're not per hour. They don't get a lot of money, but they only get a salary. So the federal government has always said, well, you can't really get around with this. So the federal government says, if you make less than $23,000 annually, even if they call you exempt, you're not exempt. In other words, if you work more than 40 hours, they have to pay you for the extra hour, and they got to pay you time and a half. Did you hear what 23,000 has now become? 47,000. It doubled. So yes, so if any of you or a member of your family is a exempt employee making less than $47,000, you hit 40 hours in a week, they got to pay you for the extra time, and they got to pay you time and a half.
When is taking place?
That is also December 1st, I think.
2017?
Yeah, quit asking me these effective date stuff. I don't have this. I just know the real important ones like for realtors, but these other laws, I have to look them up. All right. Next topic, it'll only take us about 20 minutes or so, are forms. Forms. What would be good news about forms? No new forms. Or get rid of some of the forms you got. That'd be good news, wouldn't it?
Yeah.
I have no new good news. No, just Actually, earlier this year, we did get rid of 3 forms. Did you notice that? We got rid of the trust listing agreement, the probate listing agreement, and the mobile home listing agreement. Now, for those listings, you would just use the regular listing form and use the probate addendum, probate listing addendum, the mobile home listing addendum, or the trust advisor. See, we got rid of 3 forms. Anyway. All right, let's talk about forms. CAR changes the forms now twice a year. June, December. First, let me tell you what happened in June, then I'll tell you what's going to happen December 12th. The good news as far as June is there was basically nothing happened. There were exactly 2 new forms that came out. One of them might be relevant in Kern County, and that is, it's the seller agricultural property questionnaire. We have the seller property questionnaire if you're selling a house. We have the vacant land questionnaire if you're selling land. But now we have a disclosure form if you take a listing of a family farm. Combination residence, farm. We now have a disclosure form for the seller to fill out on the farm portion of this property. Is it a mandatory disclosure? No. But it does protect the seller. It's a good form. Check it out if you list a farm. Okay? The second and only 2 new forms came out in June is called the Wire Fraud Advisory. Not required, but recommended. All this form does, you give it to the buyer, it warns the buyer of what's happening out there, which is what I'm about to tell you is, you've heard about this. This is happening literally 10 times more in 2016 than it did in 2015. It's that much of an epidemic. And that is bad guys stealing identities, then lurking, following people around until they get into a real estate transaction, following the transaction until it's time to wire money to escrow, and then impersonating the escrow company very convincingly, sending an email to the buyer and says, these are your instructions where to send the money. And the buyer sends the money, and they're not sending it to escrow, they're sending it to Timbuktu. They're sending it to Russia. Who knows where they're sending it, but the money's gone forever. This has happened to people I actually know. It's happened to friends of mine. So all this form does, it protects you by warning your buyer, hey, before you wire money, you might want to verify by calling the escrow company that you really have the right instructions. And don't call the phone number on the email you got. That is the help desk for the criminals. And I kid you not, they'll actually answer the phone and say, oh, it's a good thing you called. There's a lot of fraud going on. Yeah, good.
As they're defrauding.
As you're defrauding.
Yeah.
These are the bad guys talking to you. They're so sophisticated now. So anyway, it's a good form, wire fraud advisory. We're not required to do it. So 2 new forms came out, not required, no big deal. That was it. That's all that happened so far this year.
Why don't they put that on the statewide?
They thought about that. I guess they wanted to emphasize the uniqueness of it.
Yeah.
Don't ask me why questions. I'm not on the Forms Committee. Forms Committee does what it does.
Notice it more if it's on a separate form.
Probably notice it more on a separate form. All right. Now that leads us to December 12th. What are you going to see? Well, you're going to see a few new forms, more than 2. But none of these are going to be mandatory. None of these are going to really upset you. In fact, a couple of these you might actually like. I've already told you, by the way, that the carbon monoxide detector form is going to be expanded, right, to be the carbon monoxide detector and water conserving plumbing fixtures form. And I already told you that the seller property questionnaire and the exempt seller disclosure forms are going to have a new question on water conserving plumbing fixtures. So that's already. And I already told you, if you were paying attention, that there's a new mandatory commercial lease addendum that you must give to your new commercial tenants immediately. So in addition to that, what's happening? Well, 6 new forms. Don't get upset. The first 2 are not really new at all. You know the representative capacity signature form? Like if the seller's a corporation or the buyer's a trust or something, the purchase contract now requires them to add that to their offer or add that to their acceptance, basically saying, yes, I swear I am the right person to be signing here. And remember, then that was expanded to the listing contract now. So when you take a listing and the seller is a corporation or a trust, they're supposed to attach that to the listing form. Well, the only new thing is now it's going to be part of the lease forms. So now we're going to have a representative capacity signature disclosure addendum for landlords and one for tenants. So it's not really a new form, but it sort of is. So you got that? No big deal, right? Okay. Which leads me to, there are 4 brand new forms. Brand new. You've never seen them before. And they're all good. Well, they're all useful and they all have a reason. The first one is called the Agent Commission Sharing Agreement. This is because it's become extremely common in California now for agents to partner up. Sometimes a team, sometimes just 2 agents working together. And they partner up and they don't sign a contract, and like any marriage, when they get divorced, there's issues. There's you owe me money. No, you owe me money. You know, what about the listing we got? That was my listing. No, that was our listing. You know, et cetera, et cetera. We just see this constantly. We hear it on the phone constantly. There are disputes between partners and team members over money, commissions. So you don't have to do this, but it's recommended that you might want to, if you're a partner or a team, you might want to think about actually having a written agreement between the 2 of you or more of you, saying who gets what happens when you leave, you know, what happens, etc. Just to put it in writing, because I guess the scary thing is partnership agreements between agents can be verbal. But if it's verbal, you're going to disagree. Oh, I didn't say that. Yes, you did. We have witnesses. You know what I mean? It's just a good idea to put it in writing. You know what really triggered this, of course? I think I told you about this case last year, where the 2 realtors in Los Angeles are partners at a Keller Williams office, and one of them leaves the Keller Williams office, goes to a new office in Beverly Hills, a completely different broker, different company, completely different, but he didn't terminate the partnership agreement with the first agent at Keller Williams. So at his new company, he's fortunate enough to connect with the buyer of a lifetime, the buyer of his dreams, the buyer of everyone's dreams, the buyer who buys a $15 million mansion. And it closed, and he got a check of $210,000. You know, you can live a couple months on that one, right? So that was, Best day of his life, by far. Until his friend back at Keller Williams calls him up and says, "Way to go, partner." And he's like, "What do you mean, partner? Yeah, we were partners back at Keller Williams. I'm in a new company. You can only work for one company at a time when you're a salesperson. Obviously, you can only get paid through one broker at a time. Obviously, I'm in a whole different environment now. This whole deal I did now was under my new broker, knew everything. Leave me alone." Guy back at Keller Williams said, "You owe me 105. Long story short, they went to court and he got his 105. The court basically said, you know, there's no rule that says you can't be partners at different companies. Seems crazy. You can only get paid through one broker. And the court said, yeah, you can only get paid through one broker at a time, but there's nothing illegal about obligating yourself to pay part of that commission you just got paid to somebody else.
Wow.
So yeah, wow is correct. We were shocked by that case. Not only were we shocked that the court said you can be partners at different companies, but the court also said agents can sue agents directly for sharing commissions. For 31 years in real estate, one thing I've always known is if anyone owes you money in real estate, it's your broker or your client. Another agent can't owe you money because money goes through a broker. Court said this isn't money going through a broker. The commission was paid. But you agents agreed to divvy it up. And that a contract that you guys made is enforceable. And as I keep telling you, this could be verbal. So the moral of this is next time you're out drinking with your realtor friends and, you know, you put your arm around your buddy and say, I bet we'd be good partners. Another drunk realtor at the table is going to say, I heard them enter a partnership agreement. Yeah, I heard that.
Oh.
You know, so now you've committed yourself to millions of dollars of commission. So just be careful, and you might want to put it in writing. That's what I say. All right, that's one new form. Second new form. Now, when I tell you this form, you're going to say, oh, bad idea. And it is a bad idea. I don't want you to use this form. This is the form I call the don't use this form form. Why is CAR coming out with a form that you shouldn't use? Because your clients are doing it anyway, and if they're going to do it anyway, at least you have a form to protect them as much as possible. What are you talking about, Gov? Quit teasing us. Okay, the form is called the Buyer Early Occupancy Addendum. See, I knew you were going to groan. Because you know it's a bad idea to let the buyer move in early. Why is it a bad idea for the buyer to move in early? Well, for the obvious reason, from the seller's perspective, that when you move in early, you know the seller now has a tenant there. And if they don't close, you still got this person living in your house who didn't even buy it and they're not paying rent. Bad for seller to let tenant move in early, buyer move in early. I think what people really don't know is it's even worse from the buyer's perspective. Because you don't know this probably, but in California law, if you're in escrow to buy something and you move in before it closes, the moment you move in, the buyer has assumed the risk of loss concerning the property. Meaning, you're closing in a week. You move in today. 2 days later, the house burns down. Buyer, it's your responsibility to rebuild the house. I don't care who caused the fire. You assumed that risk when you moved in. Oh, by the way, you don't have insurance, do you? Of course not. I'm not on title. Do you see why you should never move in early as a buyer? So why are we giving you this form? Because buyers are doing it anyway. Buyers and sellers don't know the law, and you don't necessarily know the law. You're not a lawyer. You don't have to know the law. So they're doing it anyway. So at least now you have a form to give them that basically warns them. It says, don't do this unless you get legal advice. So, and you're going to point out to them, you know, my lawyer at CAR told me how bad this is, so you really better think hard about doing this. You probably shouldn't do it. But if you're going to do it, I'm going to give you this form. You're going to sign it and give it back to me, acknowledging, you know, you're told, and plus you and it's going to at least deal with, it protects people as much as it can be protected. I would look at it this way. If you're in a situation where the buyer's going to move in early, number one, try to convince them not to do it. If that doesn't work, try to convince them to sign the interim occupancy agreement. We've had that form for 30 years. That's a rental agreement. And if you move in early with a rental agreement, you don't assume the risk of loss. And at least from the seller's perspective, they signed up as a tenant and they're at least paying your rent or something. But if you have a buyer and seller who want to agree to let the buyer move in early, and they don't want to sign a rental agreement, well, then you say, well, then sign this form. In other words, you hope you never get to the point where they're going to use this form. But you see what I'm saying with me on this? What if they just want to move their crap into the garage? That's going to be our next form. Yeah, right. The move your crap into the garage form. Basically, whether that's a good idea or not, at least that doesn't give the buyer the risk of loss. Just don't let them sleep there, okay? Yeah.
That was my question.
Yeah.
Do you mean possession or?
Possession, I mean sleeping there. Putting their crap in the garage. If you want to let them do that, that's not going to trigger all these bad things. I mean, it's going to cause problems. There's still like insurance issues to think about, damage issues. What if by putting their crap in the garage, they damage the garage and then they don't I mean, those are still things to think about. So yes, there actually, in all seriousness, there probably is going to be a form on that one too. But not yet. All right, two more forms. You ready? You might actually like these two forms. Good news for once. All right, the first of these new forms is called the Summary of Offer. The idea is this. You're a listing agent. You have a listing. An offer comes in on the 10-page small print CAR form. Some of the sellers are reluctant. Am I going to read this thing? Yeah, you should probably read it carefully. Can't you like summarize it for me easily? The important parts of this offer? A lot of you probably already do this. Especially, what if you get 2 offers? Or 3 offers? Now you got 30 pages of stuff the seller says, I don't want to read all this. Can't you summarize it? Plus, it'll make me easier to compare the multiple offers if I had a quick summary of each one. Aha, there's going to be a new form. And it's going to be auto-populated by the RPA. So in other words, this is not a contract. Nobody's going to sign it or initial it or date it or anything. It's just a tool to help you better explain offers and compare offers. So it's going to be called the SUM-RPA, Summary of RPA. It would have to be generated by the buyer's agent. So if you, the listing agent, want them to do it, you're probably going to have to put in the MLS remarks, please submit offers with the Summary of Offer form. It's going to be auto-populated. The buyer's agent is not going to have any discretion. It's going to have the things you want to know, the purchase price, the closing day, etc. And it's going to have a little space at the bottom, one last space at the bottom for you, the listing agent, if you want to add in very quickly the unique features about this particular offer. Now, yes, you still want the seller to read the entire thing. And you still have a fiduciary duty to go over it with them. But this may just make it easier on a quicker basis to compare offer 1, 2, and 3 together. Not required, but it's going to be available December 12th. Okay? The fourth and final new form is related to this form. It's for the really lazy seller who gets 5 offers, and the 5 buyer's agents were nice enough to attach a summary of offer form to each one. And then the seller says to you, the listing agent, could you summarize the 5 summaries? Maybe onto one form where I can just look at one piece of paper and compare 5 different offers? As a matter of fact, yes. There's going to be a summary of multiple offer form, which you, the listing agent, would actually have to fill out. So in other words, you would take the summaries, and based on that, you would fill out this one-page form that will summarize the 5 summaries. None of this is required. You may take a look at it. It may be a helpful tool in your life. You may like it. You may like it. So you see? So isn't that good news? No crucial new forms. No changes whatsoever to the purchase contract, to the listing contract, to the lease contracts. No changes at all of any significance. We have a slight change to the SPQ and the ESD. Slight change to the carbon monoxide detector form, but really nothing significant in the way of forms. And really, if you think about the new laws I told you about, there was nothing really terrible there. Nothing. So it's not really a bad year for new stuff. One other thing I do want to mention is, let me wrap up. Give me 5 more minutes or so to just hit upon some issues I just want to hit upon that come up a lot. And this is a slight form change. Do you ever have a seller who gets an offer, but they haven't found a replacement property, and they want to accept the offer contingent on finding a replacement property? You know we have a form for that, right? The SPRP, Seller Purchase of Replacement Property. I just wanted you to be aware that form was slightly tweaked. So notice, here's how it works. You're the buyer, I'm the seller. You submit an offer on my listing, on my sale. I want to sell you my house, but I haven't found a replacement property. So I'm going to counter you with the Seller Purchase of Replacement Property form. There's one checkbox on that form where I can say, I'm accepting your offer contingent on me finding a replacement in 17 days. Which means if I don't find it in 17 days, I got to remove that contingency. But I want you to be aware there are now 2 more checkboxes on that form. You can check a second box that says, my acceptance is not just contingent on finding a new property, it's contingent on closing that deal. And you can fill in the blank 30, 45, a certain number of days after finding it. And then there's an optional third box that if you check that, you're saying to the buyer, not only is my acceptance contingent on identifying and closing, we're not even going to open escrow on your purchase of my property until I've closed the new one. Or at least until I've entered escrow on the new one. In other words, there are more options, and just be aware of what you're checking. Maybe in this market, buyers are going to be willing to wait for all that to happen. This is the house I really want. There's not a lot of houses available. I will wait. At least we have a committed contract. You can't sell it to someone else. So just be aware that if you ever get involved in these situations, read the form carefully, see what boxes they've checked. The flip side, are you getting multiple offers? Do you have a shortage of inventory? Maybe not so much anymore, so maybe this isn't going to be as common. Or do you ever have it on the other side where the buyer says to the seller, my offer is contingent on selling my house first? Okay, by the way, a little tip on that form. I think what you need to realize is when you make an offer contingent on selling your house first, you do not have to remove that contingency on the 17th day. I know a lot of agents, they make their offer contingent on selling their house first, but then on day 17, they think, oh, I got to remove all my contingencies, so they remove all contingencies. That one contingency, you didn't have to remove it. The other ones you have to remove on day 17 or day 21. But if you made your offer contingent on selling your house first and you use that COP form, you don't have to remove that contingency until the day your house sells. Just keep that in mind. All right. Other things I want you to know about. Just a couple things the realtors are doing that they're getting in trouble for, other than not saying it's C error rather than I don't know. Don't do that. Rebates versus referral fees. What's a rebate? A rebate is a realtor saying to their client, if you list with me, I will give you cash back at close. That is legal. You can give someone an incentive to be your client. Perfectly legal. You could even say to a buyer, buy with me at close of escrow. I'll give you a gift card. I'll give you cash. I'll pay your closing costs. That's perfectly legal. The catch is, on the buyer's side, if you're offering a rebate to the buyer, you must tell the lender. It's considered a concession. It must show up on the closing disclosure. Perfectly legal to do it. Don't do it outside of escrow. A rebate to the seller you can do outside of escrow. It's got nothing to do with the loan. Doesn't matter. Okay? That's point number one. Point number two, referral fees are different than rebates. Referral fee is when you say to someone, if you refer me a client, I'll give you cash. Can you do that? Not unless they have a real estate license. So rebates good, referral fees bad. What about finder's fees? It's the same thing as a referral fee. Two names for the same thing. You cannot pay unlicensed people to refer you business on residential 1 to 4. If any of you sell land, commercial, multi-unit buildings, you can do whatever you want. The referral fee restriction is only on residential 1 to 4. And it's a federal law, not a state law. So if you pay illegal referral fees, you'll keep your license. You'll be in federal prison, but you'll keep your license. You can do real estate out of your cell in Leavenworth. Anyway, the point is, don't offer unlicensed people money to refer you business. But what about the flip side of that? What if you have a former client? I mean, every single one of you in this room hopes that by being a good realtor on transaction number 1, that those clients are going to refer other people to you for future business. You're going to do a good deal today, that's going to result in 5 referrals. You're going to do a good deal for those 5, that's going to result in 25 referrals. This is how you succeed in real estate. You all know that. So let's say I do this. Let's say I do a very good job for this client, and they're happy with me, and they refer their mother-in-law to me. They refer their friend. I'm grateful for this. We do the deal, I close it. Can I give them a thank you for the referral? Yes. Can I give them cash? Yes. Can I give them a lot of cash? Yes, because you didn't solicit the referral. In other words, you can only give money to people who aren't expecting it, who don't really want it. They just gave you a referral because you're a good realtor, but you can give them something. The stranger who's just giving you the referral because they want something, you can't give them anything. See how that all works?
So you can't send something to past clients, like a coupon that says, if you refer somebody to me, I'll give you this?
Right. That's a very good point. Don't send things to your past clients saying, it was great working with you, I hope I work with you in the future, and if you know anyone and refer me, I'll give you something. Don't say that. Say to your clients, it's been great working with you, I hope to work with you again, and I love referrals, and I'll do a great job for them. And then when they give you the referral, give them something. Of course, then they're going to say, well, that was good, now I'm going to start giving her more. That's still okay, because you didn't solicit it in the first place. It's a fine line there, but that's the difference.
It's not giving them something that says...
Right, that's the difference.
How do new home builders get away with soliciting their owners for referrals?
Well, because, in other words, how does that work exactly, for example?
So, for example,
Yeah.
tell their past clients, we will pay you $2,000 cash for a referral.
Right. And they're not realtors, probably. I mean, they're just builders, right?
They have licensed sales, like you said, licensed agents that are offering these. They are the point of contact for their buyers, and these agents are offering the referral on behalf of their customers.
Because they're builders.
You know, they probably shouldn't be doing that. Maybe you should call the CFPB. Well, now that President Trump's going to abolish the CFPB, I don't know who you're going to call. Maybe you'll be able to pay referral fees now. I don't know. The jurisdiction may go under HUD back. It may go back to HUD. But you're right, though. I think builders sometimes do some questionable things when it comes to that. But they usually got lawyers who are pretty sophisticated, so they probably are doing it the right way. So I'm not going to say they're definitely doing it the wrong way. Okay, but the real issue I wanted to raise there is not disclosing buyer commission rebates to buyers to the lender, because that's been causing problems. So we talked about that. Another issue real quick is, remember the TDS, you have to answer every question. There was a recent case where not every question was answered, and it blew up the whole deal because the buyer still had the right of rescission, even though they'd signed for the TDS, because the TDS, they'd signed for an incomplete TDS. If you sign for an incomplete TDS, you still have your right of rescission. Blow up the whole deal. You know, another thing realtors have been getting in trouble for recently that they didn't used to do? Disparaging other realtors on social media. You can get sued for libel. Just because it's Twitter or Facebook doesn't mean you can say whatever you want about another, or a client, better yet. God, I had this terrible client. You want to hear this horror story? You know, just because you put it on social media doesn't mean it's legal, that you don't have to worry about getting in trouble for that. Okay? Let's see if there's anything else realtors are doing that they shouldn't be doing that's really bad. I think that's about it. Those are the big ones that are happening out there. I mean, a little, you know what we've been noticing on the hotline? Have you ever run across this? Buyer does an inspection. Buyer finds a problem. Buyer says to the seller on the request for repair, I'd like you to fix this, blah, 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 blah. Seller says, fine, I will do it. Buyer says, great, removes their contingencies. Seller does the repair. Buyer does the walkthrough, and the buyer says, you didn't do it the way I thought you were going to do it. Seller says, I did it the way I thought you wanted me to do it. And then it blows up the whole deal. What's the moral of this story? Try to be as precise and specific as you can possibly be on the request for repair to, you know, I want it to be fixed this way, this color, I want a warranty, I want a certification, I want this contractor to do it. Whatever it is, it seems to be causing problems if you don't clarify that. Which leads me to my very last thing I want to tell you is 2 Supreme Court cases. One that was just decided and one that's about to be decided. Getting back to you rental property owners, I've got sort of good news. Let me ask you guys all a question. Forget rental properties. Every one of us that has a house, we hope it's going to go up in value. They usually do. But you know, occasionally houses decline in value. And unfortunately, occasionally you have to sell your house at a loss. You bought the house for $400,000, it's now worth $350,000, you sell it for $350,000. Can you deduct that $50,000 loss against your income? Not if it's your primary residence, right? What if it's your rental property and you sell it as a loss? Can you deduct that loss? Are you sure? Let me give you the history. If you'd asked me that question prior to 1986, I would have said, yes, you can deduct it. If you'd asked me that question between 1986 and 1993, I would have said, you can't deduct it. But if you've asked me that question since 93, I would say you can deduct it as long as you have a real estate license, which you all do. The benefit of a real estate license. The U.S. Supreme Court just sort of clarified that and said, yes, you have to have a real estate license to deduct it, but that's not sufficient. To be able to deduct a loss on the sale of a rental property, you must also be able to demonstrate that you actively managed this property. So all of you property owners, if you want to talk to your accountant about this, I'm not an accountant, but I know the accountants are familiar with this case. Just keep notes of everything you ever do in connection with your rental property. I thought about my rental property today for 20 minutes. Write that down, you know. I surfed the internet looking for paint colors for the outs. I was thinking of repainting. The more detail you have, apparently, the more likely you are to survive an audit when the IRS accuses you of not actively managing this rental property that you're trying to deduct. Just make sure your accountants have heard of the Gragg case, Gragg, that just got decided by the U.S. Supreme Court. Well, I mean, they never moved into it as a primary residence, right? But a flip property, I'm assuming you're selling it at a profit, right?
But you don't always.
But you don't always. Well, I don't know. If you've only owned the property a very short time, I don't know. They're going to say, how much managing did you do? That's a good question. That's a CPA question, but I wouldn't be optimistic about that.
Can we realtors that were licensed to practice real estate, but we're not licensed to sell loans like we used to before,
right,
are we able to give an estimate of an interest rate or actually quoted rate?
So in other words, you don't have the MLO license, you're just a realtor, but they asked you what are interest rates, you mean?
Yes.
They just sort of ask you what are interest rates? Well, sure, you can quote it. You say, I'm just saying according to, you always say according to, the interest rate is this. According to the bank, this lender, yeah, you can just say that. Yep. All right, very last topic. Save the best for last, or the most interesting for last, the most significant for last. The California Supreme Court heard arguments on the case called the Horiki case, Horiki, in case you want to Google it, on September 16th. And they have 90 days to issue an opinion, which means the deadline is December 15th to issue an opinion. This case will probably be the most significant California real estate case in at least 10 years, because the issue in this case is dual agency. Here's the issue in the case. You got two realtors on the same company. One has the listing, one has the buyer. We know the company, the broker, is a dual agent, but what about the two salespeople? We've always thought that the one who has the listing has the primary fiduciary duty to the seller. The one that has the buyer, wrote up the offer, has primary fiduciary duty to the buyer. And the broker sort of has fiduciary duty to both if it comes to that. We've always hoped that that was the rule, but it's never been clear. And it finally got litigated. It finally got litigated all these years, and the Court of Appeal said both agents are dual agents. And it got appealed to the Supreme Court. So the Supreme Court is going to decide this issue. It's going to say, are both of you dual agents, or is one of you the seller's agent, one of you the buyer's agent? We argued, we hope they say, one's the listing agent, one's the buyer's agent. You don't have divided loyalties. But they could go the other way. Imagine if they go the other way. That would be every single time you had a listing and someone else in your company sold it, you're just as much the buyer's agent as you are the seller's agent. And that buyer may call you up one day and say, let's meet for lunch. I want to go over some things with you. I need some advice and some strategy and stuff like this. And you're going to say, maybe you should call your agent. And they're going to say, I just did. I'm getting bored with the one I've been working with. I want you to help me now. Because you're just as much my agent as she is. And while we're there, I want you to give me some confidential information about your client, the seller. Because you have no more loyalty to them than you do to me. This could change your life. On the other hand, before you get too upset about this, let me ask a question to everyone in the room. How many of you in this room have ever personally been a dual agent? More than half the room. So you've done this before. You've done transactions where you had the buyer and the seller, and you closed the deal, and everyone was happy, and you didn't get sued, right? So it obviously can be done. If this case goes the way we don't want it to go, though, this may happen more often. And I think what may have to actually happen is, what'll probably happen is, and you never know what the Supreme Court's going to say in detail. So we're all waiting on the decision. We have to read the decision. And then we're going to send an email to every single realtor in California saying, this is what happened. This is what we think you should do. Hopefully we're going to say, it came out the right way. Don't change a thing. But let's say they go the other way. We're going to have to inevitably have a new form. Or maybe just a new Q&A saying, this is how maybe you're going to handle these transactions. Maybe it's going to be something like this. Maybe if you have the seller and another agent has the buyer, but you're both in the same transaction, as soon as you open escrow, you and the agent and the other agent are going to get together with the buyer and seller and say, guess what? We're a team. We're both representing both of you. We're going to work together. And you're going to have to make that work. But you've all made individual dual agency work. I don't see why you won't be able to make team dual agency work. And maybe this won't happen. I do have no prediction on which way it's going to go. And we all hope the Supreme Court doesn't go off on some tangent and say something even weirder. People are saying, is there any possibility they're going to outlaw dual agency? No, there is not. There is no possibility of that. You're still going to be able to double-end deals, and you want to double-end deals. But I just be mentally prepared for this. So in summary, and I'll stay for more questions, you have 3 things to look forward to in December. 6 new forms, the Hariki case, and the holidays. Yay! So on that happy note, do I have any more questions? Yeah.
I know with TRID and disclosures and things like that, if you have a buyer and seller, you were talking about repairs.
Right.
It's a repair and things they'd like done to the house, the buyer would like done, that's not required for the loan.
Right.
Or FHA required.
Right.
Can they do an addendum and decide to handle that between the two of them outside of escrow?
Yeah, that's a very good question. The question is, addendas you're going to handle yourself because you don't want the lender to see it, right? You have to look at the lender's paperwork. Do lenders require that they see all contractual addendas? Do they normally?
I think they normally do.
I mean, it's a murky line between what's required. I mean, if they don't ask for it, and you never sign something, but you got to be careful the loan docs that the buyer signs, because sometimes they actually commit themselves to give a copy to the lender of any contractual addendum I sign. And that's almost fairly standard on loan applications. So if that's the case, you can't do these things outside of escrow. On the other hand, there are plenty of things you can do outside of escrow that the lender never sees, that you're not violating any rules. I don't think they ask to see the request for repair form normally, do they? Sometimes they do. I mean, you can't lie to lenders, and you can't not give the lender stuff that you promised that you'd give them.
So would you check with your lender if, for example, some of it's just cosmetic stuff? So
Yeah.
it would be a concession, but if the seller agrees to give the buyer, it's a conventional, like a $4,000 decorating allowance.
Usually I think the lender needs to know about that.
And then as long as they disclose it on their TRID stuff, and
Yeah.
they should be okay
Yeah.
with it.
Always check with the lender. It's the safe thing to do. They don't need to see everything, but you don't want to be in the hiding things from the lender.
On the rebates,
Rebates, yes?
on the rebates. So at the close of escrow, we like to, at least I do, I like to give a gift to my buyers.
Of course.
Is there a limitation
No.
of what I can?
You can give them anything you want. It's a rebate, it's a gift, it's a closing gift. There's limits on what you can deduct as a business expense. Check with your accountant. But there's absolutely no limit on what you can thank your client for. Absolutely no restriction.
Now, I have two questions.
Two questions.
The first one is on the auto-population for the summary.
Yeah.
Since there is no checkbox when people are asking for financial concessions toward closing costs, that will not auto-populate, correct?
Correct. Which is why probably that's what I think the listing agent is going to put in the blank space at the bottom, because I think sellers definitely want to know that, but it's not going to auto-populate. To me, that's the key thing that this listing agent is going to add to that form, because that's sort of the key thing that's not going to be auto-populated. I agree with you.
Thank you. So the second question is, on the TDS, it already identifies that they've marked they're going to have carbon monoxide.
Right.
There's certification that I will have smoke detectors, that the water
Right.
heater will be. So do we still need to have the water heater smoke detector form, A? B, do we have to have now the carbon monoxide that's going to be modified because there's already a checkbox there if they have the appropriate plumbing? So are we going to need that new form?
She is asking such smart questions. Such a smart lady. And the answer to your question is, number one, you do not ever need the water heater smoke detector form. The reason that still exists, though, is because we still have transactions where there's no TDS. Probate sale, for example. And if there's no TDS, though, you still have to certify the water heater and smoke detector. So on a non-TDS transaction, that's the only time you're going to need the water heater smoke detector addendum. What about the other form she mentioned, the carbon monoxide detector form, which is now going to be the carbon monoxide water conserving plumbing fixtures form? That's an optional form. It's always been an optional form. It's always going to be an optional form. You're right. It's taken care of on the TDS. You never need that form. We just recommend it. It's a good form, but the carbon monoxide detector form has never been and never will be mandatory. And the smoke detector water heater form is only required on a non-TDS transaction.
Is there any talk of changing up the request for repair, response, and all that?
Yeah.
Well, you know, they keep changing it already. There used to be just request for repair, RR. Then they split it into the RR and the RRRR. And then they sort of came back a little bit by saying, if the seller's response to the buyer's request is to simply say yes or no, you can do that at the bottom of the RR. You don't need the RRRR. So you want to change it even more? You just want to,
Keep it simple.
well, you got to figure out what you want and go to your CAR directors who can go to the forms committee and say, this is what we want.
What do you think of this situation? The buyer makes a repair request. The seller says, no,
Right.
I'm not doing anything.
Right.
The buyer signs off on the contingency regarding investigations of the property, but refuses to acknowledge on the repair request that they accept the seller's response.
Yeah, as long as they remove the contingency, I don't think it matters that they don't acknowledge the response on the RR. The key thing is they remove the contingency. That's a good question, but yeah. Yeah.
You know, we have some very intelligent and savvy investors and brokers here that refuse to provide the SPQ, even though in the contract it states it's required, the TDS is required. They don't fill out the TDS and just say they've never lived on the property, that they're, or they're selling it as is. What do you?
Yeah, I mean,
are intelligent people.
Yeah, these intelligent people, yes. The TDS is required even though you didn't live there. The only time you're exempt from the TDS is probate, REO, bankruptcy, new construction, and certain trusts.
And it doesn't need to be completely filled out.
It doesn't. So you can say I don't know anything, but put no on everything. No, I'm not aware. No, I'm not aware. No, I'm not aware. Okay, that's point number one. On the SPQ, you're right. It's mandatory in the purchase contract now, and the first 11 questions are mandatory by law anyway. If they don't want to do it, they're violating the law. So what? The buyers say, well, I want the house. I guess I'm going to buy it without these forms, and then if there's a problem later, I'm going to sue them. It doesn't invalidate the transaction or anything. They're not exempt from doing it. They're setting themselves up to get sued by not doing it, but if they're so smart and sophisticated, they're willing to run that risk, and the buyer's willing to buy it. The buyer still has rights, you know. That's the way it is.
Just want to make sure everybody heard that.
Yeah.
Looks like I'm done. Happy holidays. See you next year.
Very good. Thank you.